So what are the three most important estate planning documents that anybody can have no matter what the size of your estate? The three most important documents an individual can have are the durable power of attorney, the healthcare proxy, and the last will and testament. So let's talk about what each document is and why you should have each of them. The first document is the durable power of attorney. Now, there are different types of powers of attorney that you can have, but for the most part, the durable power is what we will focus on because it's durable in scope as far as powers are concerned, and it's durable in time. Now, a durable power of attorney is a written agency that you, as the maker, could put in place whereby you appoint somebody that you trust to act on your behalf. Now, this, along with the next document, are two estate planning documents that only exist while you're alive. So this is an agency, and so what you're going to do is appoint an agent called an attorney-in-fact, not an attorney-at-law, and that attorney-in-fact can step into your shoes at any given time and do anything that you could do with respect to your assets. That would be your investments, your bank accounts, your real estate. There are also some other general powers that are included in the durable power of attorney, like the power to represent in front of a court of law and the power to represent in front of an agency like Medicaid, or in Massachusetts it's called Mass Health. And now, why would you want to have a power of attorney in place? Well, if something should happen to you where you're either sick or not competent to make your own decisions financially, your friends, loved ones, people that you trust will not have to approach the probate court in order to petition for a conservatorship over you to take care of your financial affairs. Your durable power of attorney would be in place. The next important document, or as I said previously, agency that you would put in place would be a healthcare proxy. Now, a healthcare proxy is a written agency whereby you're going to appoint a healthcare agent to step into your shoes only if you're not able to make your own decisions medically. And so what a healthcare agent can do at that point, if you're in a state where you can't make your decisions, is receive the information from the medical personnel, from the doctors, in other words, and make decisions on your behalf with respect to your care. Now, once again, this document is only around while you're alive. When you pass away, it terminates. Now, why would you want to have a healthcare proxy in place? Well, if something happens to you and you cannot make your decisions medically, whether you become incompetent or you're in a state where you're not able to inform the doctors as to what you want, your healthcare agent would be able to step into your shoes, receive all of the medical data, the medical information from the physicians, and then make decisions for you medically. Without this document in place, your friends, your loved ones, people that you trust would have to approach the probate court in order to petition for a guardianship over your person in order to make your decisions for you medically. So the healthcare proxy is an important document. And step number 2. Now, what's the third important document of our trio? The third document would be the last will and testament. And folks, now, as I mentioned before, the previous 2 documents pass away or terminate upon your passing. So then the will would take over at that point. And inside your will, what you're going to do is appoint a manager of your estate. What used to be called an executor in Massachusetts is now called a personal representative. That person would step into your shoes as if you were still alive, pay off all of your debt, and then distribute the money the way that you so instruct inside that document. And in that way, the will would handle any assets that would be in your name individually. Now, usually, as I say in past videos, your estate is composed of probate assets and non-probate assets. Typically, the non-probate assets are anything you hold jointly or appoint a beneficiary for. And typically, your assets that are probate are things that you hold in your name individually, without anybody else, without any beneficiaries. And those are the assets that will pass through your will. So that is the last of the big 3 documents in anybody's estate. Now, be sure to check out some of the video links that I have included inside the description of this video. If you're watching Facebook, it would be above. If you're watching YouTube, it'd be below. Make sure you check those out. If you are watching me on YouTube, make sure that you subscribe in the lower right-hand corner. If you're watching me on Facebook, make sure that you like the video. And if you're watching me on YouTube, some of my related videos will be appearing here. Make sure that you check those out as well too. Dave Ceruolo, CeruoloLaw.com.